Dominic Pezzola, one of the Proud Boys charged in the J6 cases, filed a couple of motions. One big one is this renewed motion to dismiss, and the government has responded. So Pezzola is saying this case should be dumped. It is invalid, and we're going to go through the arguments here in some detail. And this is a good one. Now, when you're a defense attorney, as I am, you love the opportunity to bring in every one of these arguments and just stack them like this. This is a beautiful opening to a motion. You feel good. You're feeling great. It's like when you put on a new suit, you go, man, I look good right now. When you're writing this motion, you're feeling pretty dang good about this because so much has happened right in the middle of trial. As I was explaining earlier, this is kind of a weird thing when you have a seismic shift in the entire culture. Elon Musk is saying free Jacob Chansley now, okay, for crying out loud. I mean, what the heck happened? Everybody's talking about it and everybody is saying this is insane. So you're a defense attorney, you're going, wait, is it Christmas already? What happened here? Where did all this come from? You're feeling pretty good, you're looking good, the suit fits. So this is 8 pages and this got filed on March 12th, 2023. Out of the DC court, it's U.S. of America versus Dominic Pezzola. And so let's take a look at who these outstanding defense attorneys are. We have Roger Roots chiming in here, who drafted this motion. Let's see what it looks like. He writes, now, defendant Pizzola's renewed demand for dismissal and an evidentiary hearing. So he's going to dismiss it again, renew it again. He already filed one of these. We're going to sort of catch up on this. Also, a memo. He's saying that Pizzola's due process rights have been violated. Sixth Amendment rights have been violated. He's saying that the scope of cross-examination for Agent Miller needs to be investigated. Agent Miller was Nicole Miller, who was the FBI agent who said, oh, here's all my communication. She gave everything over. She said, yeah, this is what we talked about. It's all in here. And then, is that everything? Is there anything else in here? Nope, that's everything you got. Well, it turns out they unhid a bunch of the Excel spreadsheet rows, and there was a bunch of other communications in there that, oops, Special Agent Nicole Miller just forgot it. There's also in this argument a request for an appointment of a special master and or special counsel. And so we love these requests. Now, this is all being filed on behalf of Dominic Pezzola, but he's not alone. Other defendants are filing other motions, and we're going to see what the judge had to say about this today after we read through all of these motions as well as the government's response. And so as we go back to the filing, they say, all right, here comes the attorneys and we are asking for the following. 1, we submit that Nicole Miller's messages from fellow FBI agents, they say that these contain extremely casual discussions of evidence tampering, witness tampering, destruction of evidence, fabrication, altering of documents, all relating to confidential human sources among Miller and her FBI colleagues, which is a big, big statement there. I want to make sure we're clear on this. The original motion was this. This was filed back on 3/9/15. And if you remember, the FBI agent that we're talking about, her name is Nicole Miller. And these are some of the messages that she was sending back and forth. So before we go back into Pizzola's new motion, these are the spreadsheets that I was talking about. So they're saying that she's communicating with somebody else, in this one, T. Wang, and saying that they are editing out whether a confidential human source was present. This message says you need to go into that confidential human source report you just put and edit out that I was there. Okay, so manipulating evidence, involving confidential human sources, pretty catastrophic, pretty serious stuff. That was filed back on March 9th. And so we're going to pick up from there. The judge said, this came out in the middle of basically of a hearing. And the judge said, all right, everything is continued. We're going to postpone everything, brief this stuff up, and then we'll come back and argue about it. So this was the motion that they were originally referencing. Now, back to Pizzola. We're going back to Dominic's motion. They say that all of those spreadsheets constituted evidence tampering, witness tampering, destruction of evidence, fabrication, alteration. What do you mean go in there and change that somebody was there who was not there? You say person A was in the room and I need you to go in there and change it and say person A was not there anymore? How is that even remotely above board in anybody's reality? So the lawyer here says, these acts constitute serious federal crimes, including obstruction, fraud, evading a taint team, evidence tampering. Lawyer says the unceremonious and uninhibited nature of Miller's discussion of committing these crimes suggests that the FBI has a culture of corruption and lawlessness that must be immediately stopped and fully investigated. And as we were reading through the spreadsheets last week on the prior show, that's what we felt. We thought that these guys were like 9-year-olds joking around, sending messages about taking out their target's PayPal accounts. Let's go after his wife and wipe out her PayPal. She's got an Instagram account. Let's take that too. They're just kind of psychos, honestly, with unlimited power, without any authority, without any oversight over their authority. Even when they get caught red-handed, you're going to see what happens. So the defense says further, Special Agent Miller's hidden messages reveal casual discussions among the FBI regarding the monitoring of co-defendant Reel's strategy. That's Zachary's strategy. We're going to read his motion next. Reel's defenses and interesting points and ways they can get around those defenses. So they're snooping on the attorney-client privilege phone calls. Defense says that contrary to the U.S. government and their assertions, this monitoring of attorney-client privileges was explicitly intentional. It was knowing, systematic, and it was willful. They said, we need to find other emails. They were rummaging through the garbage. Additionally, these messages indicate that Miller, special agent, and the FBI's awareness that the government's conspiracy claims in this case are false, and that such allegations can only succeed by trickery and overzealousness by the U.S. Attorney's Office. Somebody said, quote, my assistant U.S. attorney is just a little overzealous. And a lot of those messages were referencing that. They were saying, is this going to get us over the hurdle? Is that going to be enough for the conspiracy charge? Because they had nothing. Now, there was a couple footnotes here, which we'll fast forward through. We have a lot to get to. They say that Special Agent Miller, of course, is the very agent who lied to Jeremy Bertino during the government's interrogation of Bertino in order to trick Bertino into falsely pleading guilty to crimes he didn't commit. They said that he pled guilty on his own and did it falsely. Now, they're also saying that the DOJ is saying, no, all of those information, all of those spreadsheet rows are confidential. They say, well, you can't see that stuff. It's classified. And we demand that this FBI misconduct be concealed and withheld from the public and clawed back, which is why we're talking about it today, so that they can't do that. But if the documents are, quote, classified, Agent Miller and her colleagues are guilty of mishandling classified materials. So if you want to use the classified defense, well, then why are they talking about classified things openly in a link channel? They casually discuss emailing the materials to their personal accounts. Okay, I'll send that to you again. What's your personal email? Right, so you can't have it both ways. If it's classified, then why were they mishandling classified information? Oh, I guess it's okay if you're an FBI agent or you're a Democrat. They don't get their houses raided. But if you're a Trumper, then you definitely do. So the defense says, additionally, after last Thursday's court session, they say that counsel for the government began altering their description of the materials in their emails to defense counsel, calling Agent Miller's messages now classified or sensitive information. All right, so they send over a spreadsheet. The first one says, this is what you need. The second one, they redact it and they say, oh, now suddenly this row is classified, or now this row is now classified sensitive FBI information. They're just making it up. Defense knows of no designation that is called sensitive FBI information. What the hell did that come from? They just made that up, which justifies withholding information from public scrutiny. Now, at the time of this writing, the defense says, the government lawyers have produced no logs, no entries, no processes or description of any logs or entries indicating the messages went through any type of classification processing. And from this, they say, the defense believes that this claim of classified materials are just a ruse and a fabrication designed to withhold this evidence of the FBI wrongdoing and bad faith from the public. Yeah, if it makes you look bad, then you can't delete it. What's the next best thing to do? Classified. Oh, that's classified. Yeah, I mean, it does have evidence of my direct criminality. Yes, I know that is true. It is weird that happened, that it's in there, but it's also classified now. Yeah, but I have it in my hands right now. It says that you murdered that dude. I'm sorry. You're not allowed to see that. National security, classified. All right, so that's basically what's happening now. FBI is like, oh, shoot, better classify that. Now, even if these revelations were legitimately classified, this would mean that defendants are being deprived of important evidence in their case, and they're being deprived of their right to put on a defense. If so, the case must be dropped by the U.S. And were this trial to go forward, this would be a due process violation, given that there is evidence that the government carefully crafted its prosecution around defense strategy communications, spying and tapping into the phone calls. unlawfully, unintentionally, and systematically and deliberately gained a benefit from the attorney-client privilege. They say no new jury, no new trial could cure the violations because they've already tainted the trial, right? They've already gotten the conversation between the defendant and the defense lawyer in their mind. And so this can't be remedied by just getting a new jury or doing this all over again because they have got inside information. It's like if one football team got the entire playbook of the other team, could you just play the game again? Not really, right? I guess you could, but you'd have to really think that through if they knew everything that you were going to do. Now, given that the FBI agents in this case have, one, engaged in evidence tampering by the destruction of hundreds of pieces of evidence. FBI destroyed hundreds of pieces of evidence, alleges the defense, and engaged in the fabrication of records and evidence tampering by altering documents related to a confidential human source. And three, that they knowingly monitored the witnesses and family situations in order to pressure them. They say this case is tainted beyond repair. They say this case must be dismissed entirely and with prejudice. Now, they say even if this court overlooked this massive trail of FBI corruption and the trial were to proceed, defendants have a right to cross-examine Agent Miller, the allegedly lying FBI agent we talked about previously, the one with the spreadsheets. Regarding all these crimes, her missing emails, her discussions of violating the defendant's Sixth Amendment rights, her discussions of evidence tampering, and her discussions of altering documents. Each of these revelations are admissible as impeachment and credibility evidence, and we can use these things. Now, they say, Judge, all January 6th prosecutions should now be paused for evidentiary hearings and investigations, and we need our own special master and our own special counsel appointed. Why? Well, because the FBI agent, Miller, her discussion with other FBI agents of evidence tampering is so casual that it evidences a culture of corruption amongst the FBI. It cries out for the immediate halt to all J6 prosecutions. And not only did FBI agents examine attorney-client communications, but they did so knowingly. They did it intentionally. And they did it with the intent to craft their cases in response to the intercepted communications. They said, quote, I need to find other emails, these sneaky FBI agents. Oh, I got one. There's more where that came from. Let's go after the wife. At no time did Agent Miller or any FBI agent rebuke or denounce a colleague during the discussion of these crimes. Now, further, there is mention of evading a taint team in Miller's messages, the FBI agent. Upon recollection and belief, they say Miller's fellow FBI agents indicate hopes to avoid taint review, meaning the FBI is explicitly making a mockery of the 4th, 5th, and 6th Amendment restrictions in order to wrongfully convict defendants. They don't want to go through a procedure that triggers a taint team review because that would really slow their process down. And of course, a taint team, as you know, want to make sure that you don't gobble up like when the FBI went and raided Trump's residence and rummaged around Melania's closet. They didn't want to gobble up all of the attorney-client privileged information. So they brought in one team to go gobble it up, another team to look at it all, and then teams to separate it out. And they put them into, this is attorney-client privilege buckets, this is not. Here, the FBI is saying, I'm hoping to avoid the taint review completely. I don't want anybody looking at any of this stuff. Now, they say that this is very reminiscent of FBI's COINTELPRO. They say on March 8, 1971, a cab driver, a daycare provider, and 2 professors broke into an FBI office in Pennsylvania to rummage through FBI cabinets. As activists in the anti-war movement, the activists suspected that they would find files on themselves, and they stole more than 1,000 classified documents. Now, hunches proved to be correct, they say. The FBI had been engaging in massive unconstitutional surveillance. The files revealed an alternate universe among FBI spies and officials where the Constitution meant nothing, and virtually every limit on the Bureau's authority was systematically disregarded. They say the FBI tried to pressure newspapers to hush the story, but the news ultimately broke of the FBI's counterintelligence program, COINTELPRO, a covert program of spying, disruption, entrapment, and illegal operations, footnote 8. They continue. Forgery, blackmail letters, illegal payments, threats, illegal operations. They became evident throughout the files. FBI agents were even trying to blackmail Martin Luther King, MLK, into committing suicide. One purpose of COINTELPRO was to spread fear of the agency's lawlessness and to enhance paranoia among critics of the government. Sound familiar? Now, he says, fast forward to today, March 2023 in this case. After 50 years, the horrors of the FBI's cult of omnipotence has resurfaced. They're everywhere. The claim of, quote, classified has a notorious history in federal court documents. It is significant that the very first time the U.S. government used the word classification as an excuse to convince courts to cover up the documents, it was later proven to be fraudulent, called the state secret privilege from U.S. versus Reynolds. So accordingly, they say the public interest in this case outweighs any government interest in concealing these documents. And so finally, they say the public's interest in the lawlessness far outweighs the interest in keeping any of the information concealed. Therefore, they're asking for the following. This is from Roger Roots. Dismissing this case with prejudice, appointing a special counsel, appointing a special master, scheduling extensive evidentiary hearings, and releasing defendant Pizzola from custody. Signed off on by Roger Roots. Interesting motion. And we see that the government will respond to this in short order. Now, that was on behalf of Dominic Pezzola. And so the government did respond. That was a renewed motion to dismiss, and Dominic Pezzola has filed several of them. But let's see what the government says in response to that. Now, here's what they filed. 10 pages, filed 312. This is the government's opposition to a dismissal or a mistrial. Now, here's the defense of the Tucker Carlson videos, essentially. This is the DOJ responding to what Tucker released, they say. In his filing, Pizzola moves the court to dismiss the case against him due to recent revelations on the Tucker Carlson show. And we watched many of those videos here, including the one that showed police taking Jacob Chansley all over the place and opening the doors for him. They say that that video from Tucker purportedly proved that Congress overreacted. Pizzola says his case must be dismissed. But they say these arguments are not connected to reality. First, they say all the footage of the Jacob Chansley video that aired on Tucker Carlson earlier this week, they say it already had been produced to the defendants in discovery. So they say that Tucker didn't even have anything new. That's the DOJ. We gave you guys all of that stuff. So I got a big question about that one. Did Jacob Chansley's first lawyer have all of that? Is it sitting in his file? Did he review it? Did he present it to the judge? Did he make any arguments in any of his negotiations with the DOJ about that, mitigating what Jacob Chansley did? I don't know. But it's a good question, because if it is in their discovery, if they did disclose it, there's typically receipts for this stuff. You know, when you pick up discovery, they don't, you don't just walk by and say, hey, good to see you, John. Thanks for my files, right? You sign it out. You say, I got this thing. In some cases, they make you pay for it. In some cases, they make you exchange a CD or a thumb drive for it, you know, just so you could have a record of this. Because the last thing that you want in a trial is for a defendant or a prosecutor to present something in court and for the other side to say, what the heck is that? I've never even seen that. You haven't disclosed that to us. I've used that in trial. Judge, I don't know where this evidence came from. They never disclosed that to me. And they say, yeah, I did. And they flip open their file and they say, and they go, oh, crap, I didn't disclose that to him. Guess I can't use that now, right? And I know that. But here we have the question about this. Was any of this disclosed? There should be records. All right. Second, there has been overwhelming evidence of the dangerous riot at the Capitol, they say, which was brought about through the actions of Pizzola and his co-defendants. Overwhelming trial evidence that the dangerous riot was brought about through the actions of Dominic Pezzola. This is one of the most insane things that we've seen come out of these cases, is that every single individual co-defendant or defendant, these are co-defendants, but every defendant is like singularly responsible for insurrecting America and interfering with democracy on that day. They're all responsible for it. even though you could sort of apportion the responsibility, like break the pie chart up, and you could say every single defendant, if there were 950 of them, each one of them maybe has a 1/950th piece of the entire ordeal. But they don't do that. No, they say everybody gets 100%. Dominic Pezzola, 100%. He brought about the dangerous riot. Okay. Third, they say the attorney-client communications in question were not privileged. They say that these were taking place on an overtly monitored jail email system, which is just, I mean, that's really pushing the boundaries on that. Well, you knew it was monitored. You knew we were monitoring it. And so if you wanted to communicate through that email, you can do it. And they've been available to the defense ever since they were produced. And fourth, Pizzola's other claims of misconduct by the government have no basis in fact. Let's see what they say. They say, one, the government has already produced the videos shown on Tucker Carlson. They say we gave all this stuff to them anyways. Beginning on Monday, March 6th, Carlson's show began airing portions of the footage. We watched it. Based on what was shown on the television, Pizzola now asserts that the government withheld some of the footage. Both claims are false, they say. The videos were, in fact, produced in discovery. So Pizzola, now, we have a question about Chansley. His case is closed. He's already been sentenced. He's, I think, getting out of custody this year. He's here in Arizona. His case is closed. Now, there are mechanisms that people are investigating about reopening it or accelerating his departure and other things, probably all long shots. But this case is wide open still. So now we're asking, is that relevant to this? And here they say that Pizzola's motion describes shocking footage of Chansley walking calmly through the halls of the Capitol. Now, Pizzola quotes Chansley's former lawyer saying that footage was withheld. And the government says, well, it wasn't withheld and it wasn't shocking anyways. They say it comes from CCTV cameras. It was produced en masse, labeled by camera number, and it was given to all defense counsel in all cases. With the exception of one CCTV camera where said footage was 10 seconds and implicated an evacuation route, that's what they did not give, all of the footage played on television was disclosed to the defendant and to Chansley by September 24th, 2021, right? So they're saying that Tucker didn't have anything new. Chansley had everything. Pizzola already had everything. The final 10 seconds of footage from what they didn't have was produced in global discovery on January 23rd, 2023. All right, so now that's getting close. Like that matters. That final 10 seconds matters. That could be key. That could be the exculpatory information right there. So they say, but they still say that they had it. So they would have had it before the trial started. So they say that Pizzola's Brady claim fails. And they write, while discovery in this case is voluminous, the government has provided the defense counsel with all the necessary tools to identify the relevant cameras to determine whether the footage was produced or not. So accordingly, the volume of discovery does not excuse the defense for making reasonable efforts to ascertain they got the footage before filing on inaccurate and inflammatory allegations of discovery failures. So they're saying you already have all that footage there. You didn't get anything new. And so now if you're a prosecutor and a judge, you're asking the defense attorney for the receipts. All right, where are the receipts? Who's got the receipts? You say you gave it to them. You say they didn't give it to you. So if the prosecutor just holds up a receipt and says, yeah, they got it as part of batch 27 on, April 4th or whatever, here it is. Now it goes back over to the defense. And if they're just sitting there saying, well, judge, they gave me like 45 million hard drives. Like, how am I supposed to find it? The judge is going to say, well, that's probably on you. You got to figure that out. They say that the videos are not exculpatory. Even though we gave them to them, they're not exculpatory. They say that Pizzola is only taking snippets of Chansley's movements to say that there was no emergency. They say Tucker's footage also lacks context of what happened before and after the footage, which is fair. I think that is a fair argument, but that same argument can be applied to the entire January 6th investigation. All of it was taken out of context. Kinzinger and Cooper are playing around saying, well, anybody can take anything out of context and you can make World War II look like a picnic. But they did that. That's what the J6 hearings were. They went around and they found the worst, most violent, snippets, and they smashed them all together and played them on loop on repeat. So Chansley, they say, entered the building as part of a violent crowd. I think there was also a New York Times reporter who was like the fourth person behind him. I think Chansley may have entered behind a New York Times reporter, whoever that guy was. He was like the fourth person in the building. So yeah, really violent. That some guy's walking around with the camera. Oh, what's going on here? Right now, and just as defendant Biggs had recounted in a recorded statement, by the time that Capitol had been breached, Chansley rode his coattails through the sheer force, and they vastly outnumbered the U.S. Capitol Police Force. Maybe that's because Muriel Bowser and the Sergeant at Arms for both the House and the Senate and the Capitol Hill Police all several of them requested support, and you didn't have it there. Vastly outnumbered. Now, so I guess they're going to blame every single person for that because they were incompetent and they couldn't protect the congressional building. And you heard other videos of police saying that they were misled, that they were put around different locations and that they were set up, I think is what one of them said. Now, as a result, for a period that afternoon, those defending the Capitol were in triage mode. Yeah, waving them in, we watched them wave them in, trying to deal with the most violent element of those unlawfully present. Okay, and remember, according to their 24-month numbers, there's less than about 300 violent offenses. Okay, just so we're clear on that. Less than 300. Somebody said I missed. Oh, here, yeah. Access as a result of Pizzola's destruction of a window. There you go. Okay, so there's the violence. So here, that came in from Lance. You missed where he said destruction of a window. There you go. He broke a window as a result of Pizzola's destruction of a window. Forcibly breached, Chansley rode Pizzola's coattails and was then walking into the building. As a result of the period, they say protecting those members and staffers who were still trapped in the Capitol. All right. So Chansley's now piggybacking on Pizzola and the violent breach of the Capitol provides more than enough evidence, they write. But there is more evidence of other conduct, right? Now here, the televised footage only shows Chansley's movements between 2:56 and 3 p.m. Prior to that time, he had other acts. Yeah, he breached the police line. 30 minutes in the Senate chamber doors, proceeded to scream obscenities while other rifled through. In sum, they say Chansley was not some passive chaperoned observer. He was there for an hour, and he was unlawfully inside the Capitol for the hour. That's interesting, yeah, because Ray Epps was also inside the Capitol, and he was also screaming obscenities about, invading the Capitol. He was there. We heard from his deposition. Now, Ray Epps, as we know, didn't enter the Senate gallery, and Ray Epps didn't have a costume on. So that's why he's probably not in prison. Now, he was part of the initial breach of the building, as was Ray Epps. He confronted law enforcement for roughly 30 minutes just outside the Senate chamber, gained access to the Senate along with other members of the mob, and he left the Senate floor after they were able to arrive en masse to remove him. Then they forcibly escorted him out, they say. And again, we've seen videos of that. He sort of walked out of the building. So in any event, they say these circumstances do nothing to mitigate Pizzola's criminal exposure. So that's Chansley's video. And Pizzola is saying that it should apply to him. So they're saying here that Pizzola's conduct is separate and apart from Chansley's. Therefore, this argument is mostly irrelevant. So they are taking this back to Pizzola's case. They were counting the votes. They say, all right, the rest of this is sort of recreation of the timeline. Here's the section on communication. Now, this is about the attorney-client privilege stuff. They say that here, Dominic Pezzola claims that the FBI had been monitoring privileged communications of him and defendant Real. The government, they write, has not obtained any privileged communications. We explained this previously. When they communicated with one another, Jonathan Mosley was his prior attorney. They're saying they waived the privilege when they were communicating. All right. And so this is, in sum, they write that all of this is basically baseless. Therefore, this case should be denied. The motion should be denied and the case should not be dismissed. So signed off on here by Jason McCullough and Connor Mulrow. And the other attorneys, the other filings will bring up some of the other issues a little bit more thoroughly. So, for example, we'll turn our attention back over to these two defendants, Nordine and to Zachary Real, to see what they say, because they bring up some of these other issues, in particular about hiding evidence and about impinging upon attorney-client communication.